So a shareholders agreement is another important agreement, not always used, but oftentimes used with startups. And essentially what it is it's an agreement between the owners of the company, the shareholders, that governs how their ownership will be managed with regard to the company. And so the sorts of things that it will cover will be who has what ownership percentage in the company, and how decisions are made about very important issues. So for example, if the company is going to get sold, if it's going to be merged with another company, which shareholders or how many shareholders votes do you need to carry that decision? So it's a way to sort of manage some of the important decisions in a company. It also is important in managing what happens if there's a breakup in the company between the founders, or if one of the founders wants to depart or wants to sell his or her stock in the company. How is that process managed? So oftentimes you'll see rights of first refusal that'll be included in a shareholders agreement to allow either the company to buy back stock that a particular founder wants to sell or a particular shareholder wants to sell, or for the other shareholders to buy that person's stock so that you can keep it close to the family, so to speak, rather than having the stock sold to someone who may not be as invested in the company's success. Other transfer restrictions may be included in a shareholders agreement as well. You can also cover, and a lot of times you'll see covered, the sorts of events that might occur for shareholders that would impact the company. So as an example, if a particular shareholder gets divorced, sometimes depending on the divorce settlement or agreement, that the spouse of the shareholder might end up with the stock of the company, and that may or may not be a good thing for the company. So sometimes there'll be a provision that'll cover what happens in the event of a divorce. So for example, if there is a divorce prior to the spouse of the shareholder getting the stock, the company will have the right to buy that stock, again, to keep it within the company and the existing shareholders' hands rather than having it go to another person. A couple scenarios may be if there's a disability that occurs for a particular shareholder who may be pretty pivotal for the company's success. What happens and how do we transfer that person's stock if they can't be involved in the business or don't have that influence that they might previously have had? Or if a person wants to resign and not be involved at all in the company, or wants to go a different route and go work on some other venture. So there's a number of different scenarios that might come up. Divorce, disability, death might be another one too. What happens if one of the shareholders passes away? Does the stock go to that person's estate, or does it get bought back by the company or by the other shareholders? So you'll see oftentimes those sorts of provisions, as well as a number of other provisions, but essentially all geared towards governing the relationship that the shareholders have vis-a-vis the company that they own.